Hi, this is Pat Iyer, and I hope you'll have a chance to join us at our October 23, 24, 25 Legal Nurse Consulting Virtual Conference. This is our second conference that's taking place online with an opportunity for you to connect with your colleagues, get inspired, get motivated, and get educated. The link for signing up for the conference is lnc.tips/October 2020 virtual. We'll have a full assortment of interactive, fun activities and sessions brought to you by attorneys, physicians, legal nurse consultants, and business leaders. To jumpstart and ramp up your business for 2021, join us at our conference. We'll see you there. And if you're watching this video or seeing this after our conference is over, we will have the recordings available for sale so that you can catch up on everything that you missed. That link again is lnc.tips/October 2020 virtual. Hi, this is Pat Iyer with Legal Nurse Podcast, and today I have with me an attorney named Stephen White, who practiced medical malpractice and personal injury law for many years in the Northeast before he retired and moved to Florida, and now he provides support services for several attorneys, and primarily for Helen Strategakos, who has a law firm in Tampa. Stephen, welcome to the show. I'm so pleased that you could join me today.
Thank you, Pat. My pleasure.
We focused in our conversation that we had before we started recording about the role of a legal nurse consultant in evaluating a case. And I know that you've seen many complex medical cases over the course of your career. Tell me, from the perspective of evaluating a case, what are some of the most important factors that you have seen that are ones that should be included right at the intake stage?
Well, at the intake stage, obviously, every case has both a liability component and a damages component, and you have to evaluate whether the healthcare practitioner at whatever level, nurse, physician's assistant, physician, surgeon, followed the reasonable standards of care for somebody in that medical specialty. From the perspective of a nurse consultant, what I recommend is they put themselves, in essence, in the shoes of that practitioner. What were they seeing? And then what were the standards of care that that practitioner should have followed to evaluate the case? Obviously, a bad outcome is not negligence. A bad outcome is not malpractice. And probably 1 in 10 or less cases that we ever review would ever be considered sufficient for purposes of accepting to go further into the process. Now, in Florida, you need to have an affidavit of a similar specialist that there was negligence for something called pre-suit. But regardless of that step, it's all about seeing what were the protocols of that particular, say, hospital, in the case of a hospital, or what was the standards that a reasonably skilled medical practitioner should have followed when seeing a patient presenting with those signs and symptoms, or in the case of a surgery, where there was a misadventure of some sort. Was that something that is just a complication that does happen? It's not negligence. The best surgeon on the planet could have still had that kind of complication. So we're very conservative on the plaintiff side, which is where I basically worked, and certainly on the defense side, you're going to support the physician or whoever the practitioner is in the same way to say it's bad outcome, but it wasn't negligence.
And I know that causes a lot of questioning of all of the players involved. Is what is the difference between a negligent act and a complication? And I know you must have researched this or looked at that, but I know from experience that torments people, because the surgeons will say, oh, expected complication, known outcome, I wasn't negligent. And some of the times that's true. But what about the other times? How do you tease that out?
It's a process. The first place to go are the medical records themselves. So, you go in a typical hospital admission, you may have a stack 4 or 5 inches high, printed out. And of course, we try to get these things electronically now. And we go through every page, basically. We look at, the labs. We look at the diagnostics. So we look at the imaging studies. We look at what's been posted and written down by the various practitioners. We've had many cases in which we feel that some of the important steps were overlooked. And that became the basis for the theory of negligence in the case. And it could be a nurse, it could be a physician's assistant, it could be the supervising physician, whoever it might be. So many of these cases present in the emergency departments. Some may be in an ICU, and then of course you have your regular med surg and your surgical procedures, but the majority of them usually present on an emergent basis. So you have to look at that context very carefully.
You made a great point, and it's something that legal nurse consultants hear from attorneys, is that they go through their medical records. One of the selling points that we have as professionals is the ability to do that record review for the attorney with the marketing approach of, these medical records are complicated. It will take you a lot of time. You may not have the expertise. You might not see it clearly because you don't have a healthcare background. So I'm curious about how that played out in the practice that you had, the decision to do it yourself versus hiring a nurse. Can you comment on that? And I know I'm putting you on the spot.
Well, no, that's fine. You have to think on your feet when you practice law, believe me. I would say it comes down to this. The attorneys, the paralegals, where we have experience in a particular medical field from prior cases or from research, we form an initial opinion as to whether the case has potential on liability. Even if it has potential on liability, the business of law, it can cost, $250,000 to take a complicated medical malpractice case to trial. And the damages may not justify that recovery given the inherent risks of litigation. Mm-hmm. You can go through that whole process. It's emotional, it'll take many years, and you could lose. So unfortunately, from the business side, some cases are we pass on because we can't show that there's going to be enough of a recovery. It could be a function of age of the patient. It could be a function of the dependents and whether, what kind of recoveries there could be. It could be a function of what's the disability that resulted. We've had a case in which there's been disfigurement. Well, if the disfigurement happened in a person who's 75 as opposed to 25, it's going to, facial disfigurement, it's going to have a big impact on potential damages. Mm-hmm. Unfortunately, sometimes, the law firm is also a business, and it can go out of business if its expenses exceed the potential recovery. And that's just, another variable that goes into the decision. However, once we decide that the case has potential, then you have to find an expert who will give an affidavit that there was, in their opinion, medical negligence and specify what it is that they felt was done improperly that goes beyond merely bad outcome. And with that, we can trigger a 90-day pre-suit process, which is off the record. In Florida, you can take essentially unsworn statements that cannot be used in court later. It's sort of like in a mediation where nothing said there can ever come out in front of the jury. So if the case isn't resolved, and many aren't, you file suit. Now you got to do it all over again, but it's some sort of informal discovery of the facts. Now, much of what happens in these cases is not just on the surface, and this is very important. Medical records are not the complete story. We highly recommend that the nurse consultant go through and specify in discovery, requests for production of documents, for example, interrogatories, obtain each and every protocol that hospital, for example, has with respect to that process or procedure. we have discovered, literally and figuratively, that there was in one of the recent cases, they were using Sheehy's Emergency Nursing Principles and Practice, 7th edition, as a referenced source of authority for the nurses in that emergency department. There's a companion publication, Sheehy's Emergency Guide, that's also very authoritative. So when we look at that and we look at signs and symptoms and what they should recommend, that can carry weight in terms of whether the nurse in this case or other practitioner followed the hospital's own rules and regulations, if you will, because they incorporated by reference a third-party publication. Mm-hmm. Same thing would apply in a lot of stroke cases we've taken or reviewed, and there's a joint commission. And if you become a comprehensive stroke center, it's a very high standard. And we look at the Joint Commission's protocols and standards, and we had a case in which a nurse noted a facial droop. Well, facial droop is a red flag for a stroke, and a stroke alert was not called. There's the underlying theory of liability in that case. Mm-hmm. The gentleman was discharged, came back the next day, and was in full-blown stroke. And then the window of opportunity to give the proper medical therapies to try to limit the damage was too late for that. So that's a theory of liability there. So getting all these protocols, and there can be hundreds of them, get them all. You know, from a plaintiff's point of view, don't just say, give me all protocols that relate to this topic, because in the real world, you won't always get everything you want right away. So that's an area that's very fertile for finding out whether you have a strong case or you have a weaker case. Mm-hmm. I recommend doing medical research in medical journals as well, because you'll frequently find that journals will have, you'll educate the attorney by giving them good medical journal articles. Practitioners in personal injury, medical malpractice, we have a pretty good idea of how medicine works, how anatomy works, but it's the specialized condition, illness, presentation that we need to get up to speed on. And we need that to prepare the questions for the opposing expert or for our own experts. When they tell us this, that, or the other thing, we have to have some context in that. And that's where the nurse consultants can be extremely helpful in gathering up some of that, whether it's Lancet or American Medical Association, all those journals. I like to go to source documents whenever I can.
Mm-hmm. Yes, they're very helpful in terms of establishing the standard of care and then also locating expert witnesses.
Yes, for sure. And I literally have found journal articles and I've approached the authors, co-authors, to be potential experts in our cases. And in some cases, they represent, say, a manufacturer or something, so there's a conflict of interest if it has to do with the procedures for that particular, say, cosmetic laser surgery machine that may have been involved in the case. But many times that will be fertile ground to find somebody. Mm-hmm. We use directories of, expert associations and other sources to find our experts. And a lot of times from past cases, we've used people that we have confidence in as well.
One of the things that has come up, and there were a series of articles that were in the newspapers about physicians practicing medicine without having insurance coverage. And several states permit that to take place, including Florida, as I understand it. In New Jersey, where I had my business, physicians were required to have insurance. So what do you do as an attorney when you have an otherwise attractive case and yet the physician has chosen not to have any insurance coverage?
Well, Florida normally has a $250,000 minimum policy limit. So, but you may have a case that's, based on damages, a death case, dependents, could be worth, $2, $3, $4, $5 million. What do? You put the case together quickly and you try to, get a tender offer. A good physician will probably have insulated many of their assets. So again, this is the sad part of the business. In some cases, the recoveries are very limited. If the damages are, within those policy limits, okay. But Uh, Not every injury has a full and fair recovery potential, and that's unfortunate, but that is reality in our judicial system.
Mm-hmm. I know we've talked a little bit about internal protocols. Can you give us an example of a case that you were involved in where that was a real issue?
Well, certainly one specific example was a gentleman who had a groin injury with a canoe accident. And in Florida, there's a lot of bacteria in the water, and groin injuries are unfortunately a common situs of injury. Presented with a great deal of pain, had a fever the night before. A CT scan showed that there was fluid in the area. Again, by history, he had taken meds that may have masked some of the worst symptoms. By history, he had hypertension, presented with lower blood pressure, more normal range. By every indication, blood work would have been the logical thing to do. See if he had an elevated white blood cell count, give a broad spectrum bolus of antibiotics, assuming that he picked up some kind of bacterial infection, would have nipped it in the bud. The next day, he comes back after being discharged. It's now necrotizing fasciitis, needs serious debridement. He has sepsis, airlifted to a primary care hospital, much bigger hospital. They did everything they could, and unfortunately, the gentleman passed away. And that was a very large case that we've actively litigated now for the last couple of years. And it's very sad, but there's a case where we go to the protocols, we look at the guidelines, we see when you see A, B, C, and D of indicia of infection, and you basically kind of do a dance around it and don't do the obvious next step, there's our liability. And it affected pretty much the nurse or nurses, which then implicates the hospital under the principle of respondeat superior, fancy way of saying the employer's responsible. Emergency room doctors and physician's assistants are generally independent contractors. So we go after the entities that contracted with the hospital to provide those professionals. So we had multiple players, multiple defendants, some corporate, some individual, but that's how these cases actually find their way up through the legal system. So you have a lot of depositions, you have a lot of experts on both sides, you go through mediation, and hopefully you get these cases settled without having to go to trial. And a trial, you do the best you can, and you hope for a very favorable outcome for your client. And the defense feels the same exact way, by the way.
Of course. I'm curious about the liability issues because it seems like it would be up to the physician to order the blood work. What was the theory against the nurses and the PAs?
This was a case where the nurse in triage, we felt, did not properly document that there was ever a full medical history that would have disclosed prior medications taken at home that would have masked fever, masked pain.
Okay.
Now, the physician's assistant was the primary treatment individual, and pretty much just dismissed so many findings that would have, again, indicated a probable infection, and certainly had the authority to go ahead and order. He just gave pain medication, sent the patient home. The supervising physicians, there was conflict. Again, this is where the computerized medical records are very important, that should have looked at all these findings and made an independent determination, no, we need blood work. So there's where we implicated the physician, even though in the first, the initial presentation to the emergency department, really were not involved in any significant way with the actual treatment. It was a more physician's assistant in this particular case. But then the nurse before discharge should have done another set of vitals that was missed. And again, that may have indicated that the problem was not resolving as everybody had hoped, and that maybe they have to go back and look more carefully at what's going on here.
I see. Makes sense.
Yeah.
You mentioned computerized medical records. I have heard conflicting opinions from attorneys about whether they love them or hate them. Where do you stand on that?
Well, I'll give you one digression. My wife went to Tampa General Hospital when we were first married. The day they started computerized medical record keeping, they said nothing per os for some procedure that was never ordered. Nobody brought her food. I had to be her advocate. So I didn't get a really good feel for computerized medical records at the time. But for better or for worse, they are here. You have to know what they do and what they don't do, because a lot of it is semi-automated, and you have to understand that. So there'll be a certain amount of called artificial intelligence, where if certain symptoms come up, the system may generate certain entries that were not necessarily put in there by whoever was doing the posting. And this is, again, where you need to study these systems, perhaps have an IT professional explain how the systems work, and then relate that to the actual medical records that came out the back end, literally or figuratively, and then see if there's something there that's significant in the for the case.
Have you encountered resistance from defense attorneys and healthcare providers in terms of giving you access to an audit trail?
Given the fact that we usually get resistance in almost every phase of discovery, that wouldn't be a surprise. But that said, if you have a properly formulated request for production, if there's resistance, you file, your motion to compel. You go to the judge and you explain, this is why we need this audit and why it's relevant, or at least may reasonably lead to discovery of relevant evidence, which is, of course, the standard for discovery. It doesn't have to necessarily be admissible per se, but dig. Lawyers say you build the case like you build a wall, one brick at a time. And that audit could just be one brick in the much larger wall that you're trying to create for your case.
And I know that expert witnesses are one of those bricks. What do you look for as an attorney in terms of the characteristics of an expert witness?
Obviously, the CV is very important. How close, first of all, what are their certifications? In Florida, is it the same specialty or subspecialty as the physician that you want an opinion on? Or at least for trial, do they have the kind of expertise that would give them credibility in front of the jury? If you get I like to get experts that are teachers in medical facilities. They're very good at presentation. They probably have been experts in many other cases. And I have no problem with an expert that's not played, but has offered opinions for both plaintiff and defense. Because if you're a fair broker, if you will, in reviewing medical records, you're much less likely to be impeached in front of a jury for being just a hired gun. And that's always one of the defense, lawyers' main strategies. And plaintiffs, yes, and you look at the cases that they've testified in. We go to the lawyers who've hired them in the past and ask, what do you think? Did they do a good job? Sometimes they'll send us the deposition of that expert and we can review it ourselves. And that frequently will help us decide whether we think they have the not only the expertise, but also the presentation skills to do a good job in explaining the basis for their opinion, presenting the opinion, and defending their opinion in a deposition or a trial.
Interesting. I know that in the 25 years that I testified as a nursing expert witness, that occasionally the attorneys would come to me in my deposition with results that they had obtained from a data bank available only to defense attorneys or only to plaintiff attorneys. And I know that those documents exist, although I can't get access to them, but I know that they're still in a data bank because I checked on myself a few months ago.
Yeah.
I think it is a fair point that you're making, that we need to be aware of the fact that every time we testify as an expert, we are laying down a record that could come back at some future date to be used to refute an opinion or a position.
Right. Which means you got to, be honest in your expert opinion and, call them as you see them. But don't, get yourself, painted into a corner. You don't have to either, because, you make a very broad statement, and then in another case, you basically have to go in the other direction. You could find, that cross-examination a little bit more uncomfortable than you would have liked.
One of my most vivid memories was having done a lot of work for an attorney who ended up being on the opposing side on a case. And she walked up to me on the witness stand and she said, "Don't hate me, Pat, for what I'm about to do to you." Like, put yourself in that position, Stephen. Imagine how that would make you feel. Don't hate me for what I'm about to do to you. And she pulled out this report that had similar language, but it was an entirely different issue, entirely different fact pattern, completely different, but she tried to use it to tear apart my opinion. And I couldn't wait for that cross-examination to be over.
I bet. Well, and the lawyer on the other side, probably should have done some rehabilitation to see if he could say, okay, distinguish the facts. A law professor of mine made a very poignant observation. Law school is a misnomer. It should be called fact school, because in most cases, it turns on facts, not the underlying legal principles. They're usually pretty well understood. There's exceptions, but it's usually the facts. So just the facts, ma'am.
That's right. Is there any other tips that you want to leave our listener with as a result of your experiences? And let's also be sure to talk about what you're doing now. In addition to helping Helen, you're working on something that's very exciting.
Yes. Well, as a final thought, make sure that you check to see at the state level, all the licensing boards, see if there's been any prior complaints against the practitioner. That's always very important. Find their training and background, because that can lead to some insights. So that's just basic background on the practitioner that you're asked to review. That would be the other thought. As a result of COVID-19, the office has made some decisions so that I'm no longer directly helping, and it was in a paralegal capacity, Helen, because I do not practice. I'm not licensed to practice here in Florida, retired from Pennsylvania, New Jersey. So basically, my dad had Parkinson's disease, and as a result of that, he could not hold his coffee mug. It dropped and it shattered. And I invented a hands-free support system for the disabled and many others, and it helped him a great deal. He's a World War II Army veteran, retired Army officer after 44 years. He passed away in August at the age of 91. But before he died, this device allowed him to safely hold drinks. We added accessories to hold a laptop on a food tray, cell phone, tablets, quite a few, a book. And we're currently looking for licensing for that product. But anybody who's interested can, my company we started is called Adaptive Creations Group, adaptivecreationsgroup.com. And you can see some video, also another little invention to speed up making smoothies. In fact, here's one right here. We're also getting that out for licensing, but I welcome, because your nurses know what it's like to have to hold a drink, clean up when something gets dropped, help their patients. So I welcome their input and opinions as to this invention and what we're trying to do to help other inventors. So I'm sort of evolving away from the law directly, but once it's in your blood, it's hard to get out.
I know. And it's clearly in your blood, and it's clearly something that you enjoy doing and have had success with. So I appreciate you sharing your thoughts with us, Stephen. And thank you for being on the show.
Good. And I hope that was helpful. And, anybody that has any follow-up or other, general questions I can assist with, I'm more than happy to help. And you can reach me again through the Adaptive Creations Group site. And my email is swhite@adaptivecreationsgroup.com.
Perfect.
Thank you.
And thank you to you who's been watching this on our podcast YouTube channel, which is at Legal Nurse Business, or listening to this on one of the many audio channels that carry Legal Nurse Podcast. Be sure to come in next week when we have a new guest, new topic, and send your questions or thoughts to Pat Iyer at legalnurse.com. business.com, and I'd be happy to entertain ideas for new topics. Thanks so much.